I said, if I hear one more whimper about service, we are going out to Nassau County to the homes of these defendants, and we're going to serve them personally for the 6th time. And all the lawyers stopped talking to each other, and all of the lawyers looked at Kalaji. And believe me, that's the last time that I ever heard Kalaji whine about service in all the courts after that. He finally learned his lesson. Because Franklin would go out there to the defendants' homes and businesses for Franklin's very suave and very gentlemanly but deadly personal service. Not knowing a plaintiff's plan to file an amended complaint, quote unquote, is a lie. Glendora sends Forma, Polinsky, and Gilman Burke of Satterley a what happened log every single week, and Glendora has been reporting about the amended complaint since January the 12th, 1993. We are grateful the lawbreakers are not going to write another paper against Glendora's amended complaint and make her in the court all that work. They're not going to oppose this. They're going to let the motion that I'm answering here oppose my amended complaint. If they don't answer Glendora's complaint, does Glendora win the lawsuit by their default? About Judge Silverman's despicable gag order, Glendora says Judge Silverman has no jurisdiction over the Judge Bryant court. Judge Bryant was much smarter about this unconstitutional gagging than Judge Silverman. On February the 12th, 1994, Judge Bryant, tired of Kalaji's letters like the one that came in February the 27th, 1995, ordered, turning your letter into a motion, it is denied. Judge Bryant put an end to this gag nonsense in a hurry. Judge Silverman, on the other hand, made himself look silly, signing 2 gag orders to show cause and the subsequent orders to gag Glendora, along with making himself look bad all over New York courtland, signing 2 orders to show cause to rob Glendora of her costs. If he signs the second order, return date February 15, 1995, Glendora will ask the Appellate Division 2nd Department to vacate it. Judge Silverman lost jurisdiction of Glendora's case when Glendora filed her notice of appeal of damages, no fines, on August the 8th, 1994, no jail. And when Kalaji filed a cross-appeal, which Kalaji failed to perfect last Friday, February 24th, 1995, Strickland and Kalaji have wheezed 12 times. Quote, since plaintiff had repeatedly attempted to contact the individual defendants at their homes, well, defendants had to be served at their homes because the federals want it that way in their cover sheet, and defendants were crying improper service to get out of their law-breaking. Glendora had to see that the service was infallible. Glendora has never heard Kalaji whine about service again in any later courts. Kalaji wants to hide his bad legal papers from the defendants. Defendants do not want to face that they are lawbreakers, that they lie and cover up, but it is all on TV every week. So Judge Silverman's gag order makes no sense anyway. Directing plaintiff not to serve the amended complaint upon individual defendants, quote unquote, is unconstitutional. It's another infringement of freedom of speech, the defendants and lawyers' second violation of freedom of speech. This is where the mammoth fight began on November 12, 1993. This letter is less than honest in saying that Strickland, on this very day, February the 24th, 1995, Friday, when the letter is dated at 11:30 a.m., telephoned Glendora and orally stated what is in the first 2 paragraphs of the letter, but omitted that Strickland talked to Glendora about settling. Glendora has written down many thoughts about settling and has talked to many people about it. How about on the first lawsuit where I said I sued him for $31 million, how about I cut it 50%? Isn't that generous? And settle for $15.5 million. And I'll give $1 million to Perry and $1 million to Grafman, and $1 million to the church, and $1 million to you, okay, and $1 million to BRS. Pages 1 through 39 do state amply the reasons Glendora's complaint of December 6, 1993 should not be dismissed. Additionally, on all pleadings and proceedings since that date, plaintiff prays this court to deny defendant's motion to dismiss her complaint of December 6, 1993, to let this case proceed with discovery and jury in your unparalleled expeditious style, and to grant Glendora costs and disbursements and any other further and different relief this court deems fit and proper, dated White Plains, New York, February the 28th, 1995. Yours in truth, Glendora. A chat with Glendora, Box 416, White Plains, New York. Then there's the notary, and next are the exhibits. And I have to stop now because this is Ash Wednesday. It's the first day of Lent. And I have to go over to the Episcopal Church where my ashes from Palm Sunday have been burned. And we have communion. I enclose with this help reform our legal service, our legal systems. Lawyer problems, call this number. And the number is 516-777-7307. That's Harvey and Carl. And then I also enclose with it the letter from the Center for Judicial Accountability about bad judges ruining people's lives. And that's it. That is my motion, my cross motion to Kalaji's motion to dismiss my early complaint of December the 6th, 1993. That's a year and a half ago. Now, we ought to find you some jokes here. Yeah, that's me. Tomorrow I start a fast. And the cats have to go with me because the cats, no matter what you give them, they don't want to eat it. They're too finicky. So we'll all go on a fast, and then we'll be good and hungry, and then we'll eat what's here. Joanne said that she embarked on the long, painful road to thinness last weekend, but she ran into a problem right away. She can't travel on an empty stomach. Have you heard about the new Wonder Diet? Well, you eat everything you want tonight, and then in the morning you wonder why your clothes don't fit. And John is on the Army diet. Have you heard of the Army diet? Everything you eat goes to the front. And Glendora versus Cablevision, lawsuit 1. What the current project is, driving me bananas, is I have to get ready the discovery. They have to answer the questions that I want answered. And I have to get ready my demand for jury. And I have to think about settlement. Okay, that's what's going on now on Glendora versus Charles F. Dolan, John Tata, William J. Bell, William J. Quinn, Mark A. Lesgarten, Francis F. Randolph Jr., James A. Kofal, Joseph Aznara, James L. Dolan, Charles Former, Robert S. Lemley, Irvin B. Polinsky, Cablevision Systems Corporation. That's what's going on the first lawsuit. Next, we got to tell you what's going on in the second lawsuit. That's the state court. Time constraint. Points I. Judge Rosado does not stand up for the public, but for greedy big business. Point row. Judge Rosado is wrong to let CBS abuse it. Well, folks, I'm back. I'm back from church. My ashes are all rubbed off. And Katie Kitten is here. And then I had to go to edit at White Plains Public Access Commission. Wonderful editing. We got finished program 14. Katie's playing with a microphone cord. Here, Katie. Here, I'll give it to you. There you are. I guess that's what's so appealing about cats. They always play. And anyway, we edited 1692. Excuse me, 16. Yeah, that's right. 92. Scott and Broder. Then we did 1693 Cablevision, lawsuit 1, Bryant, motion. And then we did 1694. Oh, that's so cute, Katie. That was still Cablevision, chapter 114, I believe. Now we started at 1695. Now I guess this is chapter 114. It was 113. And now we're back, and we're going to tell you what happened to Glendora versus Cablevision lawsuit 2. Very big news on that, folks. Very, very big news. Cablevision did not perfect their cross appeal. This is from the Judge Silverman case in New York State Supreme Court. Cablevision did not perfect their cross appeal in the appellate division, 2nd Department in Brooklyn. You want to know why? Because they have no case. They're wrong, and they know they're going to lose. They should have realized in the first place that they were going to lose when they did this. You can't go out and break 2 laws and not lose. And the other news on Glendora versus Cablevision lawsuit 2, that would be Glendora versus Coalfault. Gee, that light is really whiting you out there, Katie. Is that we're waiting for Judge Silverman to sign the order to rob me of my costs. There's no doubt but what he will sign it. And so we're waiting for that. And just as soon as he signs it, to rob me of my costs a second time, $695 from a $1.5 billion corporation. Does that make sense? Paying $2,500 to have the order to show cause written. Okay, just the minute he does, I go to the appellate division, 2nd Department in Brooklyn, and I ask him to vacate it. And I ask him to enjoin Judge Silverman for signing any more orders to show cause to rob me of my costs. And that's by CPLR. It's 5500 is appeals generally, and that's 5517, I do believe, that says that the appellate division can vacate orders of the lower court. Now we'll have to have some jokes before I tell you what happened on Glendora versus Cablevision lawsuit 3. Have you seen those computerized scales with the talking voice? Well, Marilyn got one, and the voice said, "Please, one at a time." And Charlie says that he diets religiously, and come to find out, you know what that means? It means he doesn't eat during church. And John has eaten nothing but bananas and has drunk nothing but coconut milk. He hasn't lost any weight, but you ought to see him climb trees. Now, Glendora versus Cablevision, lawsuit 3, here it is. Supreme Court of the United States, if Katie will allow me. This was submitted yesterday, February 28th, the last day of February before Lent. Supreme Court of the United States, Glendora plaintiff against Charles F. Dolan, John Tata, William J. Bell, William J. Quinn, Mark A. Lusgarten, Francis F. Randolph Jr., James A. Coalfault, Joseph Osnara, James L. Dolan, Charles Former, Robert S. Lemley, Irvin B. Polinsky, Cablevision Systems Corporation. It's and this is my motion for leave to proceed in forma pauperis. But the petitioner, Glendora, asked leave to file the attached petition for a writ of certiorari without payment of costs and to proceed in forma pauperis. Petitioner has not previously been granted leave to so proceed in any court. Petitioner's affidavit in support of this motion is attached here too. So you see, I didn't used to be poor until I went into court and tried to stand up for my rights. And instead of finding justice, I found corrupt judges and crooked lawyers. Pursuant to Rule 39.1, Glendora states she has sought leave to proceed in forma pauperis on January 10, 1995, when she filed her petition for writ of certiorari, Glendora versus Conrad Duberstein et al., and when she filed her petition for writ of certiorari, Glendora versus Gannett et al., on February the 7th, 1995. Glendora won her fourth and final appeal to the United States Court of Appeals, Second Circuit, Glendora versus Cablevision et al., White Plains, New York, February 28, 1995. Glendora, a chat with Glendora. And here is the affidavit in support of the motion to proceed in forma pauperis. They send you this. You just have to fill it out. Then on the back, I added some more information to explain my answers on their affidavit. And I signed this too. And here's the cover page. This has to be on cardstock. And a copy of it goes to Robert M. Kalaji at Satterley, Stevens, Burke & Burke, 230 Park Avenue, that crooked law firm, New York, 10169. Now here are the questions presented. Should a United States District Court judge, that would be Broderick, allow a party to violate a United States law and get away with it? Should a citizen of the United States receive equal protection of the law pursuant to the 14th Amendment of the United States Constitution? Should a citizen of the United States receive due process, and does not due process demand that judges be completely unbiased and have no personal interest in the decision? Here's the table of contents, and here's the table of authorities, and the first law quoted is the First Amendment. I want to read you the First Amendment. Now this is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Big amendment. Very important. And then the Fifth Amendment is that, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor, and the one that we want is, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time upon, no. Okay. The one I was looking for that says you shan't be, that's it. You shall not be denied due process. And the 14th Amendment is that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without the process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Well, that's happened to me several times in the Supreme Court of the state of New York. I've been denied due process, and I've been denied equal protection of the law. Now, 42 of the United States Code, 1983, that's the civil rights one, that every person who under color of state ever deprives any rights, privileges, or immunity secured by the Constitution and laws shall be liable to the party injured in an action of law. That's what we got going here. And of course, the big law, 47 United States Code 531E, no cable operator shall exercise editorial control over public use of channel. And then the district courts shall have original jurisdiction of any civil action authorized by law to be commenced by any person to redress the deprivation under color of any state law, statute, ordinance, or whatever. So, or by any act of Congress. Okay, and then we have mental or emotional disturbance without physical effect. Here, Katie, let me show them that one. You're very good on television today, Katie. Yeah, you have lots of fans out there who watch you, and they like seeing you. And then, of course, we mentioned the New York Executive Law, Article 28, Section 829.3, which says essentially the same thing. The cable television franchisee shall not exercise any editorial control over any public use of channel. And we have the New York State Civil Practice Laws and Rules, Articles 14A, damage actions, negligence, 1411 to 1413. And now that brings us up to the frontispiece. And now the loss, well, the petition really starts right about here. The opinions below. Petitioner Glendora respectfully prays that a writ of certiorari issued to review the judgment and opinion of the United States Court of Appeals for the Second Circuit, refusing to enforce a United States law and act of Congress, and refusing to give appellant due process and equal protection of the law, and denying her right to petition her government for redress of grievances. Opinions below. The opinion of the Court of Appeals is not reported. But then, isn't it? Didn't we see it reported in a reporter? In any of the books as per their rubber stamp, 50% illegible. Glendora versus Dolan. See, this is the last page of their opinion. This would be Judges Mahoney, Daniel Mahoney, Joseph M. McLaughlin, and Gerald W. Haney. But can you read that? No, nobody can read that. That's a rubber stamp. You see this thing over here? You don't have to go, Katie. You can't read it. Anyway, it says it won't be published in any of the books, and it says that something about unrelated cases before this or any other court. It won't be cited, I guess. Glendora published the opinion on our television program, A Chat with Glendora. You're the one. You have the command. You have the control. You have the authority. Jurisdiction. The United States Court of Appeals, Second Circuit, Judges Mahoney, McLaughlin, and Haney have so far departed from the accepted and usual course of judicial proceedings as to call for an exercise of the United States Supreme Court's power of supervision. The United States Court of Appeals, Second Circuit, Judges Mahoney, McLaughlin, and Haney sanctioned such a departure from the accepted and usual course of judicial proceedings by the United States District Court, Southern District. Judge Broderick, the United States Court of Appeals has decided an important question of federal law that conflicts with applicable decisions of this court. This appeal is of a decision that allowed a defendant to break a federal law and that did not make said defendant pay his due for breaking this federal law. That would be Cablevision. Further, this decision did not do justice to the plaintiff and denied plaintiff's First Amendment right to petition her government for a redress of grievances, and that denied plaintiff due process of law and equal protection of the law. The court never dealt with the merits of the case. The issues that plaintiff Glendora brought before the court were never dealt with. It was an outrageous thing for a judge to do and for the United States Court of Appeals, Second Circuit, to affirm. This is why Glendora is before the United States Supreme Court. The opinion of the U.S. Court of Appeals, Second Circuit, was filed on December 2nd, 1994. A timely petition for rehearing was filed on December 13th, 1994. The denial of the U.S. Court of Appeals of the petition for rehearing was issued on January 17th, 1995. Constitutional and statutory provisions involve Amendments 1, 5, and 14 to the United States Constitution as set forth in the Table of Authorities, page 3. Statement of the case. The United States District Court, Southern District of New York, White Plains, has jurisdiction pursuant to Title 28, United States Code, Section 1343A4. Blank page. Statement of the case. Now, the statement of this case is the old Scott Lord story that you have heard over and over again. And here's page 2 of it. And page 3, how I was out there on Long Island reporting what Scott Lord had done and reporting his record, public record, in the probation office and in the county clerk's office and in the district attorney's office and in the sheriff's office and in the Office of Consumer Affairs. And then I came on television and told you about it so that you could protect yourselves from fraud, consumer fraud. And here's the conversation on November the 12th, when Cablevision up and broke a state law and a federal law. And Glendora told them that they had, and that there would be a lawsuit, but they did nothing about it in their arrogance and in their ignorance. And then on December 6, 1993, I sued them in the United States District Court, Southern District, in the White Plains branch. And I sued them for $31 million. They had, on the basis of 42 United States Code 1983, the one about the rights that you have under the Constitution. If anybody under color of state deprives you of those rights, that person is liable. On February 18, 1994, at 10 a.m. Friday, Judge Bryant issued a bench decision denying Glendora's complaint, although he indicated the order had already been signed to the same effect and entered. Judge Bryant kept saying two things to Glendora. One, go to state court, and two, if you don't like it, appeal. Well, Glendora did both. In lawsuit 2, Glendora sued James A. Kofalt, President, Dolan, Tada, Bell, Lusgarten, Randolph, Lemley, Asnara, Garger, Dolan, Cablevision Systems Corporation in New York's Supreme Court, Westchester County, for violation of New York Executive Law, Article 28. Cable television franchisees shall not exercise any editorial control over public use of channel. Judge Donald N. Silverman ruled that plaintiff had a statutory right to have a program on cable TV. I'm telling this to the United States Supreme Court, and it must be returned to TV on September 2nd, 1994. It was, and it has been cablecast perfectly ever since. The second thing that Judge Bryant told Glendora to do, she did: appeal his decision of February 18, 1994. On January 11, 1995, the United States Court of Appeals, Second Circuit, vacated Judge Bryant's decision and remanded Glendora's case to the United States District Court of New York. As soon as this court, the Southern District, gets the mandate, Glendora will move for leave to file her amended complaint. Glendora motioned to Judge Bryant that he vacate and reconsider his order pursuant to Rule 60b-5 on the basis that defendants had violated 47 United States Code, Section 531E. No cable operator shall exercise editorial control over public use of channel. But Judge Bryant ignored entirely the violation of 47 United States Code 531E. So to get justice, Glendora had to go to another court and pay another $120 to sue Charles F. Dolan, Tada, Bell, Quinn, Lusgarten, Randolph, Kofalt, Asnara, Dolan, James Dolan, Charles Former, Robert S. Lemley, Irvin Polinsky, Cablevision Systems Corporation. But justice she did not find. Instead, Judge Broderick ruled on May 5th, 1994, it is all right to break a federal law. It's just fine. Break all the federal laws you want. Glendora appealed this. was terrible. It was, no evidence was taken, no witnesses were called. There was no trial, there was no jury. He didn't deal with it on the merits. It was a terrible, bad, bungling job that Judge Coppola did. And he told Lazarus was his name, down in the Bronx, the lawyer for the DHCR, to submit an order. And Coppola dismissed my complaint. It was a terrible piece of work. It's typical of what comes out of the Westchester County Supreme Court. But Lazarus, let alone, he didn't even know that Coppola had made a decision. A telephone call could have told him that. There's a rule that if an order is not submitted within 60 days, then the decision is over. The decision means nothing. It's over. And so I gave him 7 more days past the 60 days, and then I told Judge Coppola. But Judge Coppola went ahead and broke the law. And as judges often do. Judges very often break the law. And so he broke the law and let him get by with it. Erstwhile, the Emergency Tenant Protection Act also says that a landlord cannot harass a tenant to move. And this landlord had harassed me 13 times to move. And I had it on audio tape. It was an open and shut case. But you can't file harassment cases in the White Plains DHCR. You have to go to the William Street DHCR in Manhattan. So I did that. And I followed their procedure. They heard the evidence on audio tape. And then they just went ahead and dismissed it. So that was crooked too. So I sued the DHCR in William Street, Cohen, and all the other people for their negligences. And Judge Coppola got that case too. Judge Coppola should have had enough sense to recuse himself. He did such a terrible job on the first DHCR case, but he didn't. And he made another dippy decision, another meritless, frivolous decision. So that's the case. Now the oral arguments, and naturally I appealed both of his decisions and orders, and that's coming before the appellate division probably sometime around Christmas. Now I'd like to move on and tell you that on Glendora versus Philip Amicone, who is the Commissioner of Building in the city of White Plains, and the former Mayor of White Plains, Alfred Del Vecchio, and the White Plains Building Department, I would like to read you my oral argument on that. Even though the Appellate Division, Second Department, New York Supreme Court bungled everything and didn't notify me of my oral argument date. And I made a motion to them, it's returnable tomorrow, to reschedule an oral argument date. It was their fault. They didn't notify me. I didn't even know I had an oral argument date. It was February 7th. And so there's the motion to give me an oral argument date, and you've already heard that. Now here is my oral argument, and I sent it to them. That would be Judges Thompson, Lawrence, Goldstein, and Hart. Hart was on my panel for CBS. Okay, this is my oral argument. Good morning. My name is Glendora, and I thank you for the privileges of this oral argument. In God we trust. It says behind your heads, may the words of our mouths and the meditations of our hearts be acceptable unto you, our God, our strength, and our Redeemer. Glendora submits this oral argument in writing, hoping you will do the right thing and read it, in case you do the wrong thing and do not reschedule her oral argument, which your court cheated Glendora out of. Glendora is a great believer in oral arguments. It is very often the only chance in the Supreme Court, State of New York, Westchester County, when she gets to see a judge eyeball to eyeball. Although it is very seldom an appellate judge will look a pro se in the eye. Judge Rosenblatt does, Judge Sullivan does, the other 10 have not. In the Judge Garayan court, everything was submitted on paper. It was a correspondence school, not a court. The most important property of an oral argument is that Glendora knows you hear her points. She has very little confidence in judges doing their homework, both in the lower court and in the appeals court, and reading the papers. This also applies to the appellate term, the United States District Court, and the United States Court of Appeals. Right now, she She is finding out if judges in the United States Supreme Court do their homework. When Glendora appears before you and tells you her points, she is reasonably confident you get them. So often the decisions judges make and the questions they ask at oral argument reveal they have not studied the paper and are not familiar with the facts and circumstances. So the big property of an oral argument is not so much that one says something new as that one is assured of being heard. The first grounds for review is that Judge Garayan's decision has to be scrubbed. It is illegal. It was late. CPLR 2919 says a judge has 60 days after a motion to render an order. Judge Garayan's order is 11 days untimely, a week and a half. There is the rule, CPLR 2919, which says, an order determining any motion shall be made within 60 days after the motion is submitted for decision. Simple. So plaintiff appellant Glendora asked this court to vacate this illegal decision. Neither Amnicone and Telvecchio, the White Plains Building Department, nor their lawyer, Robert Pagano, ever opposed this point. They never addressed it. They defaulted. The fact is that Judge Garayan's order is illegal. Judges are there to see that the law is carried out. Judges cannot go around breaking the law any more than anybody else can. For this reason, Judge Rosado's decision does not count. It should be Judge Garayan's decision does not count. It will be interesting to see how you handle that one. The whole world will be watching. This decision and order were reached without any testimony being taken, without any witnesses sworn, without any evidence taken. There was no trial, there was no jury. Glendora was denied due process. Her First, Fifth, and 14th Amendment rights were violated. It was a correspondence school, not a court. This decision and order does not deal with the issue of the negligences of defendants that injured plaintiff. This decision leaves out 2/3 of the issue. Certainly a judge is there to deal with the plaintiff's complaint and not with the defense lawyer's aberrations, extraneous, and detours. Certainly a judge should read carefully a plaintiff's list of negligences and deal exclusively with those, even though a deceitful defense lawyer tries to distract the judge and lead him astray. The next big point, and believe me, that isn't hard. The next big point is that Glendora filed her claim. She did exactly as the law department, City of White Plains, said to do. They sent her the instructions, which Glendora followed to the letter. Her claim was submitted to the law department in person. Defendants never opposed Glendora's points in her appellant's brief and never dealt with them, so Glendora wins by default. Should a building commissioner, a mayor, and a building department allow a single-family house to be illegally rented as a two-family, and all of them knew this? Should a building commissioner, a mayor, and a building department let a house go with no certificate of occupancy for 50 weeks out of the 52 weeks Glendora was a tenant in that house? Should a building commissioner, a mayor, and a building department issue a certificate of occupancy without an inspection of the house? Should a building commissioner, a mayor, and a building department protect a citizen's safety? Should a building commissioner, a mayor, and a building department ignore a citizen's letters, police calls, and visits on 12 or more counts? The defendants did all these things. They broke the laws. They were negligent in their duty, just as Glendora's complaint says. The fact that Delvecchio was not reelected and that Judge Garayan was not reelected shows that Glendora was right. The fact that the newspapers were filled subsequent to Glendora's lawsuit with articles on illegal occupancy shows Glendora was right and defendants were wrong. Defendants should pay up. The decision order was not made on the merits. Defendants have no defense and never will have. Glendora should have won on CPLR 3211B, which says, dismiss it. Defendants have no meritorious defense. The Judge Garayan court and this court should stand up for the best in public service, not the worst. Pagano stands up for the worst in public service. Judge Garayan ignored the fact that one defendant, the City of White Plains, never appeared, and Glendora should win by default. The Appellate Division, 2nd Department, has to correct this miscarriage. Judge Garayan was as derelict in his duty as were the defendants. Glendora, having watched so many sessions of the Appellate Division, 2nd Department, can understand why it's so hard for this panel to match up again, but certainly you can do something to correct this court's error. And not notifying her of her oral argument date of February 7th, 1995. It is not fair. Courts have to be fair. The law is against the defendants, the facts are against the defendants, but the judge was for the defendants. Your new courtroom in White Plains is beautiful. For the first time in 3 years of monitoring the 2nd Department, I could hear every word. Presiding Judge Mangano was thrilled with the new courtroom. Glendora watched the whole session on February 16th, 10 a.m. to 12:45 p.m. Judge Ritter said during the session, this is the quote of the day, "Being pro se is a shield, not a sword. For the life of her, Glendora cannot see why you did not schedule her oral argument in White Plains February 16th, 3 blocks from her home, instead of making her come all the way into Brooklyn February 7th. Not that I was not thrilled to be again with your nice clerks and New York court officers. Judge Van Greitelen of the United States Court of Appeals always asks an oral arguer, 'What do you want us to do for you?' The record stands not only in your marble and gold guild, but on microfiche and in the depositories on TV. There is no way defendants can cover up their law-breaking. Glendora pleads that this court grant her $30,000 damages, the cost of this action, and one other further and different relief this court deems fit. Dated White Plains, New York, February 28, 1995. Glendora, Box 416, White Plains, New York." And it says right here in the file of the White Plains Building Department that 40 Longview Avenue, or 42 Longview Avenue, which one it was we lived in, was one family, and it was rented as a two-family. It says right here in the White Plains Building Department records, approved for one-family occupancy only. It says right here, inform her, that's the owner, that the house is a class 1 family and must be something rectified. And here's a letter from Martin Brownstein and to your dear Glendora in response to your letter dated February 9, 1995. The justices sitting on the above appeal have refused to reschedule the matter for argument. That's not right. And that's Glendora versus Philip Amacombe, Alfred Del Vecchio, and the White Plains Building Department, and Robert Pagano. Stephanie is sure that her son is going to grow up to be a doctor because he collects old magazines. And Steve said to Sam, "Did the doctor give you a clean bill of health?" And Sam says, "No, he won't do that until my check clears." And the doctor told Marty to take one of these pills every day and walk a mile every day and call me at the end of the month. So at the end of the month, Marty called the doctor and he says, "Doc, what do I do now? I'm out of the pills and I'm 30 miles from home." This is Glendora's oral argument before the Appellate Division, Second Department. The judges were Sullivan presiding, and Copertino, and a new judge, Krausman, and Hart, who was also on the Amacombe panel. So I sent a copy of this oral argument, which you heard read to you last week, to every defendant. That would be CBS Incorporated and Howard Stringer, who has left CBS. To Joseph Abruzzese, to Peter Lund, to Matthew Margot, to Beth Bresson, who really started all this, and to Marty Daly, and to Matt Steinfeld. So a copy of this oral argument went to each one of them, along with the calendar excerpt of the Appellate Division, Second Department in Brooklyn, and that oral argument was heard on February the 17th. Item 22 of the law-breaking of the Walsh, El Pucci, and Larkin people, and of their lawyers, Bendish and Cousins, Wilson Bave, and of the court, that would be Carlucci Wood. And this log did get out last week, and on Friday or Thursday there was a letter from Cousins, and then came a which I answered because it was grossly unjust, telling Judge Wood what to do, and I sent it all over the state, and I read you that. And then on February the 28th, Tuesday, yesterday, we got out this letter, and it went to Judge Harold Wood, Justice of the Supreme Court, Westchester, Chief Judge Judith Kay, Judge Joseph J. Trafficani, Judge E. Leo Malonis, Gerald Stern, Commission on Judicial Conduct, Judge Angelo Ingrassia, Administrative Judge, 9th and 10th Judicial Districts, Gary Casella, Grievance Committee, 9th and 10th, John C. Cousins, Jr., Wilson Babe Law Firm, Bruce Bendish, Glendora's TV audience, that's you. To all of you, the 18th unilateral decision against Glendora and in favor of Lawyer Cousins, who runs the Judge Wood Court. 1, Lawyer Cousins to Judge Wood, jump. Judge Wood, how high? 2, Lawyer Cousins says, vacate your decision order of January 31st, 1995. Judge Wood does so immediately. Good and faithful servant Judge Wood does exactly what Master Cousins tells him to do. Cousins wanted to make sure we did not come today with the tapes at 2 p.m. So Cousins saw to it that Judge Wood stopped it. How is that for court manipulation? Judge Wood sits on Cousins' knees and Cousins pulls the strings in the back. Judge Wood will have to be very careful in the future to check with Cousins before he writes any more decisions orders, so it will not be so embarrassing all over the state of New York to modify them. Did Glendora tell you all in her February 18, 1995 bulletin that the left hand does not know what the right hand is doing? Now this is it. They demanded the tapes. Glendora said no. Judge Wood ordered Glendora to produce the tapes today. Glendora said yes, and now Cousins says no. Now Wood says no. Cousins backs down after his motion and reply affidavit were granted. After all that fuss, turmoil, and hard work on all of us, and changes his poor old mind. So it is over. He asked for the tapes and did not take them. No more discovery. Certify this case ready for trial. After 1 year, 4 months on pussyfooting, it is time this case is certified ready for trial. Judge Wood went back on his word to Glendora to make August 22nd, 1994, the day certain when all discovery would be complete. He let lying Cousins group throw in one obstacle and delay after another. The second delay was another deposition. Glendora passed that with an A+. The next delay was all tapes. Glendora called their bluff and they backed down. He doesn't get another chance. There's an order to show cause before Judge Wood to enjoin Glendora from informing the CEO of General Accident, whose shareholders are paying Wilson Babe, Cousins, Koza, Comboy, and the underlings outrageous fees. Shareholders are being sucked dry. Judge Wood has no jurisdiction over General Accident. They are not a defendant. Judge Wood should never have signed that order to show cause. It is illegal. Further, there was no law cited for its basis. The law Nescient Comboy cited applies to a temporary restraining order on defendants, not on plaintiffs. Glendora is the plaintiff. Stay tuned to see if this will be the 19th unilateral, ignominious, and ignorant order signed by Judge Wood Court. Judge Wood modifying his decision order to no tapes does not augur well for the 20th decision order coming up to dismiss Glendora's complaint. The complaint was filed November the 11th, 1993. Aren't crooked lawyers a little late? How can a complaint be dismissed when the judge has not seen the evidence, when the judge does not know what is going on? No evidence has been taken, no witnesses have been sworn, no testimony has been given, there has been no trial. How can Judge Wood dismiss a complaint? I guess you know now by how. Cousins says jump, Judge Wood says how high. It is a setup. Remember the weak Me Too Bendish paper also dismissed the complaint against the Walsh and El Pucci lawbreakers? It's 1,740 counts. It is sad. It is Judge Wood's last year on the bench, 76 years old. Franklin is 75 years old. It is a terrible record that this court has cut, and Judge Wood goes out not with a bang, but with a whimper, as T.S. Eliot says. Stay tuned. Glendora will send you a copy of number 19 and number 20. Here is today's joke. Wife, we are celebrating our 7th anniversary of marriage. Friend, the 7th is the 10th anniversary. Husband, yes, we have been eating out of cans for 7 years. Yours in truth, Glendora. And you know to whom it went. I read you the list. And here's the letter from Cousins. Enclosed, please find the written decision of Judge Wood dated February 23, 1995. Pursuant to the court's decision, the inspection of your tapes previously scheduled for February 27, 1995 has been adjourned without date by the court. You see, they think they're going to win that motion to dismiss and they won't need the discovery. Stay tuned. I'll read you the decision in order. The decision in order of this court filed and entered January 31st, 1995, which required the plaintiff to produce various videotapes and audio tapes at the Office of Defendant's Attorneys on February 27th, 1995, is hereby modified. The court hereby adjourns without date the date for the production by the plaintiff of the videotapes and audio tapes previously described pending a decision on the defendant's motion for dismissal and/or summary judgment. As a consequence of this modification, the time for the plaintiff to produce exact copies of every audio tape and videotape we're going backwards here, is also adjourned from March 27, 1995 without date. Enter dated February the 23rd, 1995, White Plains, New York, Harold L. Wood, JSC. And here are the minutes of the January 18th conference minutes I paid $15 for, and Susan Lancetta was a court reporter. Court clerk, there was a request to have this audio taped. Cousins, I object to that. We have a court reporter with a record. There's no need. It can be edited. We are before the court. Judge Wood, I will give it to her. Glendora, I object to that. I don't edit my tapes. Judge Wood, all right. Who is doing the videotaping? Glendora, it's audio taping. Judge Wood, where is it? Glendora, it's in the car, in my automobile. I don't have time to go down and get it. Judge Wood, what are we here for? Glendora, to declare this case ready for trial. Judge Wood, we got two outstanding motions. You already addressed two of them. You've got one returnable on the 30th. That would have been the 30th of January. Glendora, one of which I haven't answered, and I don't have to answer until the 30th. Judge Wood, before the 30th, they're entitled because within that period of time they might want to reply. Glendora, to me it says return date the 30th. Judge Wood, that means it comes back to the court. Are you replying to that? Glendora, of course. There's no way you can dismiss my case. Judge Wood, I haven't dismissed it. Glendora, that's what their motion is. Judge Wood, I have to see to it. You get due process. Glendora, you do. Even in small claims court, I can get substantial justice. I'm here today. Judge Wood, I got three motions. You have not had an opportunity to reply to the one returnable January 30th. Glendora, that means that's when I have it in to you. Judge Wood, you have it in by the 30th. You will? Glendora, yes, sir. Judge Wood, Judge Wood, I have never been paid. Glendora says Judge Wood, I have never been paid my witness fee for August 22nd and October 25th, $30. I've never been paid for my witness fee, $15 and $15. I mentioned that about 8 times, and these crooked lawyers ignore it. Judge Wood, I'd like to show you. Can you stand up? This is audio tapes, 676 audio tapes, and each one is an hour and a half. Would you be so kind? These are the VHS half-inch. These are my archives. There are 200 of these. See, I had them in boxes. He was sitting down. He couldn't see over the tops of the boxes, so I was holding them up this way, and I asked him to stand up and look at them. These are the VHS half-inch. These are my archives. There are 200 of those. Each one is 2 hours. The requirement would be to go through each one of those and pick out the Larkin torts. Judge Wood, what I suggest, I have no argument with them. Oh, no, Glendora says, Judge Wood, what I suggest I have no argument with them. They are entitled to see the videotape so they know how to lie when they go to court. I suggest this is what they do. This is 4 hours, this is 2 hours, and this is 4 hours, and this is of the early tortious acts of which my complaint complains. These are all strung together. It would not take any screening because these have been screened and put on the videotape. They are a master. There wouldn't be screening over here. You have to go through every tape, which are 2 hours, and you have to pick out the parts. Judge Wood, why would anybody want to do that? That's what I've been telling them all along. Glendora, that's what Kevin Odell proposed in his motion. Judge Wood, who's Kevin Odell? Glendora, he is the one of the many lawyers at Wilson, Babe, Cousins, and Koza. He proposed that. That's what he wants in his motion. Judge Wood, you already responded to that? Glendora, I did, sir. Judge Wood, you are responding to this one on the 30th. Mr. Cousins, the only thing we request is the tapes that she's produced. What that means. In front of the court, that we get copies of those. Judge Wood, at your expense. Glendora, certainly. Mr. Cousins, whatever the reasonable expense would be to run a copy of each of those tapes, I don't think it's extraordinary. Glendora, I will tell you that what the expense is. I will not let those tapes out of my hand. There is one copy. I have to be with them. I want them to put up a bond in case they are lost or damaged. Mr. Cousins, to obviate that, I ask they make a copy and give it to us. Judge Wood, you have it made and they'll pay for it. Glendora, okay. They have to find the video production house. Judge Wood, you are going to do it. You are in that business. You are taking the tapes because you won't surrender them. Glendora, $200 an hour for my time. Judge Wood, you're a litigant. Glendora, $200 per hour for the time it takes me, plus the cost of the dub and cost of the equipment and production. The production rate is $200 an hour. That's how things go in this business. This is a high-tech business. Mr. Cousins, perhaps we can hold the tape production in abeyance, pending our motion to dismiss. See, they're putting everything on that motion to dismiss. Judge Wood, you are going to respond on the 30th of January, and by that time, everything will be fully submitted. All three motions are fully submitted by that time. It will take me about 45 days, probably 30 days, to get to the motion because of the volume of work that I have. In my decision, I'll tell you when to come back to this court. Glendora, I might get your decision then by March 1st. Judge Wood, oh yes. Glendora, you must get it in before the Ides of March. Judge Wood, what's going to happen? Glendora, I don't know. That's when Julius Caesar was murdered. The court, my decision will tell you when to come back here. Well, I had the answer in long before the 30th. I had it in 7 days before the 30th. And I want you to carefully note that on the motion to dismiss, Wilson, Babe, Cousins, Koza, Comboy, Odell, McGrath, Karamitsos did not submit a reply affidavit. And then Bendish came along with saying, me too. I want to dismiss me too. Now, this is a mailing. And here it is. This little $120 lawsuit has gone up to 3 volumes. And the number of hours put in on Michael Gelman has been something like 550 hours. And the costs have been something like $85. And it's really tough to know where to begin and pick it up from where we left it before. But let me think a minute. I can remember that December the 22nd, excuse me, February the 22nd, the day before the trial, the Gelman trial, Franklin and Glendora screened audio tapes 601 to 676. And we queued up the Gelman what had to do with Gelman. All 120 Gelman tapes were queued up, ready to go, and to review what was said on them and to write it down. And here is the logging. The logging itself is 11 pages. No, it's 12 pages. No, it's 11 pages. All right, so Franklin and I started that at 5:58 a.m. And we did fine with the first 10 and with the first 20. And then the first 30, it started to get bogged down because the tapes were not queued up and the excerpts had to be found again. And so doing nothing from 5:58 a.m. until 3 p.m. Thursday, February the 23rd, 1995. And I was only up to audio tape 55 out of 120 of the Gelman excerpts. So it began to look hopeless. I had to go to TCI to edit. At 3 o'clock, I started preparing for that. And then I started packing up the what was needed for the trial, which was for 6:30 p.m. And I only had 55 tapes, so I went to TCI and started the editing. And then at 4:30 p.m., Franklin and I had to head for the south to the Scarsdale Post Office, the Bronx River Parkway, the Cross County, the Deegan, the 3rd Avenue Bridge, the FDR. There were just a couple of tie-ups. And we tried to go to the Seventh Day store near the New York Public Library on 5th Avenue and 40th Street, but the traffic was impossible, so we had to ditch that. We also had to ditch Manhattan cable TV going down there, which meant other trips, 2 other trips, and so we had to rush down to the City Court of Manhattan. I sat in the back seat of the Lincoln, queuing up audio tapes as fast as I could, getting ready for the trial to play these audio tapes showing where Gelman was showing irresponsibility and lack of ethics to do his duty, which was to return our tape, our property. And we got to the Manhattan court at 6. We found a parking place on Lafayette, that's at 111 Center Street, and Franklin took in 2 boxes of tapes. I left out 10 tapes to see if I couldn't queue up some more. What did I tell you? I was up to about 77 out of 120, and then the batteries gave out, and I only had 1 set of batteries left charged. So I had to give up that and go to the court, and we sat, and they opened the court a little late, but we sat in the front row, and that Thursday night there were only like 150 people, litigants in the court, instead of all the other nights we've been there when it's 300 and it's packed. And so one judge came in, a man, or anyway, a person in a black robe came in, a man, and that turned out to be Judge Stallman. And then another judge came in, or a woman in a black robe, and that turned out, I don't know what judge that turned out to be. But Judge Stallman was sort of personable in his announcements, and the other judges never made announcements. They just came and sat down on the bench, and at the bench. And so our Glendora versus Michael Gelman was called. Glendora stood and said, "Plaintiff, ready for trial by the court." And then another strange woman said something. I didn't get a chance to look at her until they called us down, and they didn't even have us sit in the front row. They had us stand by the calendar clerk, and my goodness, told us to go to room 106, which is a trial room, and it has "In God We Trust" on it. Over in the 107, the big courtroom, it says "In God E Trust." The W is missing. And so we went in, and there was a woman at the bench and another woman in front of the desk, at the desk in front of the bench, and that woman at the bench turned out to be Judge Sarah Lee Evans, and the woman at the other desk turned out to be the stenographer, court stenographer. And then this woman I've never seen before, I don't think, who has any legal position at all, who was appearing for Gelman and DiGiulio, said that Gelman and DiGiulio would be here momentarily, and she was standing there for them, and Judge Evans got the drift right away and says, "Oh, well, you just need more time." So in a couple of minutes, DiGiulio and Gelman came, but why didn't they answer the calendar call? And they came in from the 106 door to the hall instead of the 106 entrance from the 107 big courtroom. What were they pulling off? Gelman thinks he's too high and mighty, that he can't associate with a hoi polloi. Ginny, or Katie rather, your gluteus maximus is getting too well known on TV. So, when all were gathered in the courtroom, let me just summarize. There was Franklin and Glendora, Gelman and DiGiulio, and this unknown woman, Judge Evans, and the court stenographer. And it's a little courtroom, so it's kind of chummy and cozy. I had to pull the curtains so that Katie, in jumping up on the windowsill, wouldn't pull down the curtains and the curtain rod, as she's done several times before. These cats are such a nuisance. You save their lives, and you wait on them hand and foot for years and years. They don't do anything for you, but all they do is make you trouble. All right. Like Michael Gelman. I had an opportunity to look Michael Gelman straight in the eye for a long time and look into his unethical soul and his irresponsible soul. He was wearing a ponytail, and that makes people look like a horse's gluteus maximus. And he is young, and he has sort of grayish blue eyes. He has sort of a long nose. and he was wearing a shirt and tie and a pretty blue jacket, and the rest you would expect. So I looked at him for a long time for all of the grief that he has caused me by his irresponsibility and his lack of ethics. So I guess Judge Evans told Glendora, "Why don't you tell me what happened? Tell your story," which is good, and because she's trying to get it settled, which is good. And the rest I think I'm going to read you, that I was keeping on Wednesday and Thursday before the crush and rush took all the organization out of everything. And that was the queuing up of the tapes, 676 tapes. And I must have started that project when? Sometime in January. I guess I worked something like 30 days, and it was up to 3 to 7 hours a day on this Gelman audio tape evidence. So that would be the first page. And Judge Evans had a very appealing smile every now and then, Sarah Lee Evans. Glendora introduced her husband to Judge Evans, Franklin. So there, that first 2 pages are done. Telling of my story was off the record, and Glendora said that on Christmas 1989 she called live, and Michael Gelman answered the phone, and Glendora told Michael Gelman how she told jokes and liked to cheer up people, that she had been on David Letterman, and that she had been on the CNBC cable television network, and that she would like to send him the jokes on videotape and have him look at the tape and see if the jokes would be helpful in cheering up the audience of Live with Regis. And Michael Gelman said, sure, send the tape. He would look at it and see if it would be good for the show. Glendora sent the tape. She called to see what the answer was. Michael Gelman never came to the phone. She never talked to him again. In 5 years, she never talked to him again. The 2 file boxes with 120 audio tapes showing this were on the floor of the courtroom between Franklin and Glendora. Glendora said that she found out from Calvin Norman, her salesman at WABC TV, through Glendora TV ads, that Gelman had seen the tape, liked it, but it did not fit the format of Live. Glendora then asked for the tape to be returned. It never was. She called every week about it. Finally, it was clear to her that Gelman had lost the tape. Then she started making a demand every week for $120 for the lost tape. She made the demand for 5 years, and Gelman never paid her. She also pointed out that she had sent the tape to Phil Buth, a friend for years of Glendora, and also a friend for years of Thomas Murphy, the owner of Cap City's ABC TV. Phil saw the tape, he liked it, but he had no authority to put the jokes on Good Morning America and replace, what's her name? Irma Bombeck. It was a VHS just like the one that Glendora sent Gelman. In fact, he returned 2 of them. Phil Buth returned 2 of them, and Glendora told the judge how Michael Katz, predecessor of Michael Gelman, had been sent a tape like the one sent to Gelman, that he saw it, that he liked it, but he could not use it in his format at Arts and Entertainment, cable TV network. Katz lost the tape. He admitted that he'd lost the tape, and he said that it was UPS who lost the tape and that UPS would reimburse them. But Katz, unlike Gelman, had the ethics finally in the end. He never bothered with UPS in the end because UPS was taking, well, actually because Arts and Entertainment was negligent in sending the information UPS needed to process the claim. So finally, Michael Katz sent the money himself. He wrote his own check for $120. what a difference between Michael Katz and Michael Gelman. Judge Evans asked DiGiulio to tell his side of it. DiGiulio said about 600 words. Glendora also told Judge Evans how December 1st, Bigelow, the first attorney on the case, had called and said to Glendora, "We want to settle this and get rid of it." And Glendora was very interested, but she had 3 reply affidavits by December 2nd, the next day, and was right at the moment under the gun to get into these 3 reply affidavits, plus there was one that had to go to the Westchester Supreme Court. And at the moment when Bigelow called, Glendora was videotaping her program, and her mind was someplace else, but Glendora would call Bigelow on Friday. Glendora said she wanted to settle it too and wanted to know what the release would be like. As it was, I never could call Bigelow because of having to get these papers in, and I couldn't do anything until I got them all in, and that was by Sunday night. And by Monday morning, December 5th, which was the day of the next court appearance, the first thing I did was call Bigelow, and I called several times, but she never called back. DiGiulio called back, and I don't like that. I don't know DiGiulio, and I don't like changing lawyers in the middle of the stream. You should stay with a lawyer you start out with just as you should stay with the judge that you start out with. That's called the individual assignment system. Well, then Judge Evans explored with DiGiulio the possibility of settling it. DiGiulio was not interested in settling it. He never did show good faith about settling it. He wants the fees. He's what you call a fee sucker. Glendora said the release DiGiulio talked about December 5th over the phone was medieval, that no person in the 20th century would sign such a release. And Glendora said she had never been shown a copy of the release, that she had seen Judge Gantz look at it at the bench, and that Judge Gantz looked straight at DiGiulio and said, "No hereafter. Take out the hereafter." Judge Evans brought up the point that the lease was too broad, that it was not limited to the action herein. And of course DiGiulio wanted a lease for all time, everything before, everything after. He wanted ABC released and Cap Cities released, but ABC and Cap Cities, I didn't sue them. They were not parties to the action. I sued Michael Gelman. DiGiulio said it was a standard Blumberg form release, and Judge Evans was very enlightened, and she said, quote unquote, "I cannot make her sign a release that covers anything more than this action. It would be unconstitutional." Hooray for Judge Evans. But Judge Evans said, in effect, so much for settlement. She could see that DiGiulio wanted to go the whole gamut. And we all know why. There's more fees. He gets paid more. He's making a mountain out of a molehill. That's what it is. You know, and as I said to you long ago, Gelman should have shown up that first night, or he should have, when he got the summons, he should have just paid up. And then he should have shown up that first night, November 1st, and settled the whole thing then. I do not like the ethics and the standards and the lying and the stealing and the cheating of Michael Gelman. So Judge Evans gave up on the settlement. I want to insert here that the Yonkers Court really has a good system in small claims court for settling. First they call in the plaintiff and have the plaintiff tell his story alone without the defendant there. And then the Yonkers Court urges the plaintiff to settle. You know, after all, a trial is a roll of the dice, which it is. There's nothing definite about a trial. Never. It's a roll of the dice. And then the plaintiff goes out and the defendant comes in and the judge talks to the defendant, and I don't know what the judge says to the defendant, but has the defendant probably tell his story and probably tries to get the defendant to settle. And then the defendant goes out and the two of them are asked to come in together, the plaintiff and the defendant, and then the judge tries to get the defendant and the plaintiff to settle. It's a pretty good system. And I will add to that what Judge Kelman of the White Plains Court always says. He says that if you have a settlement, your chances of getting paid are like 80% better than if you have a judgment. So I just want to insert that. I think they have a very good system of trying to settle small claims cases. And they have a high rate of settlement and a high rate of resolution of disputes. Okay, there's a lot of typos in this report, and that's because it's hard to think and type at the same time, and Franklin isn't here so that he can type it. So I have to think and type at the same time, and that results in a lot of typos. So Judge Evans had Glendora swear in and give her name and address for the record. The court stenographer started her minutes. Glendora told the repeated chronology. Judge Evans had a very engaging smile. Glendora wanted to present her case by playing the audio tape she had been screening, logging, and queuing up 5 hours a day for 2 months, and Judge Evans would not let Glendora play the audio tapes on the basis that they were hearsay, that the person in the audio tapes wasn't here to testify. And that was, I took exception with that ruling, of course. That was my evidence, that was my case, that was a clincher. So I was pretty upset with that, and she knew when I said I take exception to that ruling that I was covering myself for an appeal to the appellate term, First Department. Or no, I don't, it's not First Department. It's something. Anyway, it is in the 9th and 10th Judicial Districts. I don't have any experience down there. It was not right. It was Glendora's case, and this was her evidence. It was not due process. So I was really upset by that. And Glendora wanted Judge Evans to look at her log, where she has the log way back to 1989 and 1990, all the things that happened in the log, which I've read to you for 5 years, and that was my evidence, and Judge Evans denied that. And I said I take exception to that ruling, and she knew what I meant. I really think that it was pragmatic more than law or hearsay or anything else, because she didn't have time to hear the tapes and she didn't have time to go through the log. However, that is my case, and I was denied presenting my case. These two denials were big blows to Glendora and to Franklin, who had worked 400 hours preparing her case and was denied the chance to do so. Out to the court that she had increased her demand from $190 to $380 because Gelman had lost 2 of her tapes. This fact of the 2 tapes had come out in the affidavits of Gelman and Calvin Norman and Glendora's account executive at WABC-TV in the audio tapes, and also in the audio tapes that Glendora had been screening for 2 months. Judge Evans opposed this. Glendora said she had submitted her notice to increase, and DeGiulio, Glendora believes, said he had not got a copy of it, and Glendora protested that she had sent it to everybody, DeGiulio and Bigelow and Thomas Murphy, the owner of ABC Cap Cities, and to Warren Buffett, the owner of almost 5% of ABC Cap Cities, and to the chief counsel at ABC Cap Cities, and to Michael Gelman. Of it, and Glendora protested that she had sent it to everybody, DeGiulio and Bigelow and Thomas Murphy, the owner of ABC Cap Cities, and to Warren Buffett, the owner of almost 5% of ABC Cap Cities, and to the chief counsel at ABC Cap Cities, and to Michael Gelman, And at that point, DiGiulio dug out the notice that said Glendora was increasing her claim to $380, and Judge Evans looked at it, and she said to DiGiulio, "When did you receive it?" And DiGiulio said when he did. I sent it out with my cross motion, with my reply affidavit to his cross motion, summary judgment, and Judge Evans said that she certainly did have the discretion to increase the amount, and Glendora said that in small claims before she had seen that done at the trial, increase the amount. And finally, poor Judge Evans said, in the interest of getting this over with tonight, that she would grant the increase. So I won on that. $380. I won increasing my claim to $380. So that was 2 victories for Glendora, that the release was unconstitutional and that the claim was increased. There's a special word for that. It begins with A. That the release was increased, that the claim was increased to $380. And insert, earlier Glendora told Judge Evans that there had been motions and that 11 motions and cross motions had been denied by Judge Schaefer, and Judge Evans said, so we start out with a clean slate, I guess. Judge Evans did not seem to have the file. She seemed to have only a paper, a half sheet. And I don't know if this is so, but I don't see how it could be so, but I just got that impression. This time Glendora asked to see the paper that Judge Evans was looking at, the notice to increase the claim that DiGiulio had given her, and I should have done that the time that DiGiulio had given Judge Gantz a release to look at. I should have said, let me see that paper, because after all, both sides have to see what goes to the judge. DiGiulio was in his usual bad temper. He was really awkward. His tactics really did not fit the procedure of small claims. His cross-examination of Glendora was heavy like a piano instead of light like a flute. His questions were prolix and convoluted. Glendora had to compart them and take them one section at a time. He made statements sometimes instead of questions, and the questions were way too long. One was about how easy it is to make a duplication of a tape. Glendora also told the court in the first run-through that DiGiulio had wanted the release to include ABC and Cap Cities. Glendora said she had not made them parties to the action, that the only party to the action was Michael Gelman. And this is Ginny Cat, heavy Ginny Cat, who was all belly. That's good, Ginny. You sit on the papers and you block the light. The Judge Evans agreed with this, and DiGiulio said, I have to protect my clients, and questioned that no matter how they lie or how they steal or how they cheat, DiGiulio has to protect them. Question, why did what DiGiulio was really saying, I have to receive checks from my clients. Why did Michael Gelman wait until the Friday before the first court appearance, November 1st, to retain counsel? Can anybody figure that out? He had the summons was served on him September 20th, and he waited until the Friday before November 1st, which was a Monday, to retain counsel. Tell me, why? Michael Gelman really stacks up to be a great person, doesn't he? Back to DiGiulio's cross-examination of Glendora. He fell into the pit most lawyers do when asking Glendora about her TV shows. He asked if she broadcast discussions of her lawsuits on TV. I got disgusted with him. Instead of clearing up his language, I said no. She gave him, because I don't broadcast, okay, and I don't have discussions. She gave him another chance to rephrase his question accurately. He fluffed twice. Finally, Glendora said to him straight, it's not broadcast, it's cablecast. It is annoying enough to have lawyers so pro se about TV, but it is exasperating in DiGiulio's case when here he is representing a broadcast client, ABC, Cap Cities. Glendora also said there were no discussions, that she was the only one on the program, that they were reports. DeGiulio was not fully aware of the facts and circumstances and never has been, neither is Gelman. He asked Glendora if she were employed, and Glendora said no. He should know that Glendora is self-employed through Glendora TV ads. The worst thing he did was try to make the judge swallow that Glendora brought the lawsuit against Gelman to have more material for her TV program. I hit the ceiling. Glendora said that's a lie. Glendora explained that she did not want her program to be about lawbreakers and about lawyers in courts, about the bad things people do. Glendora wanted her program to be about the good things people do, and it always was, up until these lawbreakers started doing just that, breaking the law. It had a feature Careers Unlimited to tell children how to get into certain fields and succeed. For instance, Robert Wright, the CEO of NBC, did that. Okay, Ginny. This lie about filing lawsuits to get material for her show was a scandalous nadir. It was a desperation for Gelman and DeGiulio because Gelman has no defense and for not returning the Glendora's videotapes, 2 of them. Life is easy when a cat sits on your work. Okay, let's put this over in the pile that we've read the people. Now, that's it. Chew the papers, put holes in them. Glendora cannot wait for these lawbreakers to be brought to justice so she can go back to telling about the good things people do instead of about the bad things people do. But our programs are helping people. She got so many telephone calls from people about them. Glendora protested DeGiulio's distortions with vehemence. The poor court stenographer had to stop the exchange 3 times because a court stenographer cannot write down simultaneously what 2 people are saying. The unknown woman who answered the telephone calls, the calendar call, sat in the courtroom throughout. Franklin sat behind Glendora to her left. It was a chummy courtroom, kind of nice and conducive to small claims. Judge Evans had a very appealing way at the bench. She kept the order and kept it flowing. She spoke very softly. When the calendar clerk looked at the door, when the calendar clerk looked in the door, and the New York State Court officer, we have seen there so many times, looked in the door, Judge Evans said, "We are almost through." Oh, that was news to me. I didn't know I was almost through. Insert. In the courtroom, the great big courtroom, 107, there was a little boy. He was about this tall. I'd say he's about 5 years old. And he belonged apparently to one of the New York State Court officers. I don't think that's right. I don't think it's good for the little boy, and I don't think it's good for the court. He shouldn't have been there. But he was awfully cute. And he sat there, and he was fascinated by the computer. And he was putting in numbers and looking up at the screen, and putting in numbers and looking at the screen. That was very cute. I hope he didn't ruin any of the data in the computer. Glendora called Franklin as a witness. Glendora was worried about Franklin. He didn't look good. He was flushed. He didn't take off his raincoat all the time he was in the courtroom. He was very annoyed by DeGiulio's posturing and lies and crookedness. He even broke down at one point, Franklin did, and shivered and shouted. He was, of course, very upset by the denial of the audio tapes be heard, and he was very upset by the log denying to be heard. It bothered him when he was giving testimony that he was gagged, that he wasn't allowed to say what he had to say to contribute to the facts. DeGiulio accused Franklin of hearsay when Franklin said he'd heard the conversation with Gelman Christmas Day 1989. Franklin was properly annoyed and said loudly, "It was a speakerphone." And you know, Franklin's not like that. Franklin's very soft-spoken and very gentlemanly. Glendora forgot to ask Franklin if it were recorded, and Franklin was there when it was recorded. Glendora told the court that we had screened 676 audio tapes for 2 months, 7 hours a day. Each tape was 1.5 hours long, and we were nonplussed why we could not find that conversation Christmas 1989, Glendora and Gelman, that Franklin witnessed. I just you know, I couldn't believe that we couldn't find it. And we certainly went through those tapes, every second of them, up as far as audio tapes 370. And then we started going through the tapes by the index. But at that point, there were no 1989 conversations or 1990 or 1991. They were all 1992, 1993, 1994, and 1995. So it's a great blow to us that we couldn't find that Christmas conversation with Gelman in 1989. We both know it was recorded. Apparently it got erased. Okay, it really was a bad blow. It's devastating. We feel very badly about that. It is the clear recollection of both of us that we had it on audio tape. DeGiulio asked for a copy of a receipt or check that we paid $120 for the Gelman dub, but that is a misrepresentation, a distortion. First, Glendora had to go out and do the program in front of a live audience, the Eastern Star in Harrison. Then it had to be edited down to 10 minutes because the live program was 30 minutes. Then a master had to be made, and then dubs of the master had to be made. It was a work project. It was an art project. The value of that tape to Glendora was $120. At that time, Glendora pointed out to the court that was a very cheap price, that WABC-TV at that time was charging $500 for a dub. Glendora also pointed out to the court that she had several tapes to play the court where she asked people if they wanted a dub of their interview on a chat with Glendora for $120. $120 was her price. That is what she got for a VHS in those days. Today, she would charge $200, and at that time, ABC TV was charging Glendora $500 for a dub. Well, that's as far as I had chance to write this log for you. And now I've got to go type some more and come back and read it to you. But I was interrupted by 26 hours it took to answer Kalaji's motion to dismiss my complaint of December 6, 1993 in Glendora versus Cablevision for censoring my program. The case, the decision of Judge Bryant, that was vacated by the United States Court of Appeals and remanded. And that case is up and rolling very, very fast and very hard. So 26 hours I had to do that. And then I had to protest Judge Wood being bossed around by a lawyer named John Cousins, and about changing his decision. Cousins told him to vacate his decision, and Judge Wood does everything that Cousins tells him to do. And so I had to protest that to Judge Trafficante, Judge Malonis, Judge Kay, Judge Ingracia. And then I had to finish Glendora versus Cablevision, Charles Dolan this is. It's really properly called Glendora versus Charles Dolan et al. Cablevision lawsuit 3. I had to send my informa pauperis and my petition for writ of certiorari to the Supreme Court of the United States. So the Gelman stuff, the last I worked on Gelman was Saturday, but I did, even though I couldn't get my audio tapes queued up, I got 77 out of 120. You know, when you start out to do a job, you still got to finish it, even though it's too late. Oh, see that sunshine. Oh, the weather's been so beautiful. 40 degrees. It's just been beautiful. We've only had 2 bad storms this whole winter. It was February 4th. 10 inches of snow when the pine tree lost its life, and the cold that came, 8 degrees. That's the only 2 bad storms we've had. Other than that, the weather's been perfect since August. So when you start a job, you got to finish it, whether it's too late or not. So all day Friday, and I mean all day Friday, from 6 a.m. to 7 p.m., I queued up and logged the rest of the Gelman audio tapes, 120 of them, so that here is the contents of the tapes. And I'm going to videotape those audio tapes for you so you can hear the record. I couldn't play it in court, so I'm going to have you hear it. So what would that be, from 6 a.m. to 7 p.m.? Maybe 13 hours, wouldn't it? All day Friday, February the 24th. And then all day and about 6 hours Saturday, I typed this for you. So as I say, the time on Gelman's about $550 and the costs are about $85. And so now let me go to the typewriter and finish typing out this report. Okay folks, it's 4 hours later. That was at 8:15 and now it's 12:15, and I finished writing what happened in the Judge Evans court on February the 23rd, 1993, Glendora versus Michael Gelman at the trial. And the trial went, we were in court from about 6:30 p.m. to 9 p.m. But we must stop for some jokes. Paul says that his dog plays poker, and Jonathan says, really? And Paul says, yes, but he's not very good at it, my dog. When he plays poker, he gets a good hand and his tail wags. And Peter says that he is an inventor, and that he has just invented, he's just crossed an electric blanket with a toaster, an electric blanket with a toaster so that people will pop out of bed in the morning. And Johnny rode home from college to his father. He says, Dad, I went to the drama club, and he says, they gave me a part, and he says, I'm playing the part of a man who's been married for 30 years. And his daddy wrote back and says, good, son. He says, on your next play, I hope that you get a speaking part. And now we will continue. This is the part I read you. 2 sides. And here's where I resume typing. I read you that side. And this is page 442 of the Gelman log. Glendora versus Michael Gelman. Glendora also pointed out to the court that she had several tapes to play the court where she asked people if they wanted a dub of their interview on a chat with Glendora for $120. $120 was her price. That is what she got for a VHS in those days. Today she would charge $200. At that time, WABC-TV was charging $500 for a dub. And to DeGiulio's and Gelman saying how easy it is to make a dub, why was ABC ripping people off charging $500? You know, DeGiulio made a big point how easy it is to make a duplicate, he called it. It's a dub. And Gelman was saying, you push this button, you push that. It was so silly. And so if it was so simple, how come WABC-TV was ripping people off charging $500 for a dub? Glendora won on chattel, 3-year statute of limitations. DeGiulio and Bigelow kept saying that this was for recovery of chattel, and the statute of limitations was 3 years, but they gave up on that entirely. It was never mentioned at the trial. So we won on that. DeGiulio tried to list Glendora's other lawsuits or other fights for rights. Glendora objected that that was irrelevant to the case at bar, and Judge Evans stopped DeGiulio's laundry list immediately. DeGiulio got into Gelman's, it is not our policy to return unsolicited videotapes. This is a defense for having no ethics, no responsibility, for negligence. Gelman and I talked about the tape, and so they drop into a recorded announcement that they don't return videotapes and audio tapes. That excuses Gelman for his lack of ethics? No way. Franklin pointed out that Gelman and Glendora had the conversation about it. Glendora points out that Glendora made over 200 oral demands for the videotapes, that these demands were on the audio tape sitting right there in front of them. DeGiulio was saying the value of the tape was $8. Glendora said that was with nothing on the tape. Glendora was saying production charges and talent charges and creative charges. It was 7:06 p.m. when Judge Evans made her decision they were going for trial, that DeGiulio was scuttling any settlement. This, of course, was for the fees he would get from Gelman. He wanted a trial. The more he drags it out, the more he gets paid. DeGiulio kept lying. Glendora's case has no merit. At 7:09 p.m., The trial started on record, and the stenographer started taking it was for and why. And then the judge explained how small claims works. Well, Glendora knows pretty well how small claims work. Glendora is good at small claims, it seems. She has won all of them. Cablevision, $200 videotape they destroyed, and that was a commercial that was going on WABC-TV. The Lydia Marble case, the Yonkers Court breach of contract Brower, the White Plains breach of contract martial arts, Estavis returning the security deposit. Glendora knows plaintiff is first. Glendora, and the most recent one was the Lydia Gallicano res judicata one with Judge Freya. Glendora knows plaintiff is first. Glendora reads the small claims book cover to cover over and over again. Judge Evans kept saying as succinctly as possible. Judge Evans kept saying that the court is not concerned whether Mr. Gelman is a nice person, but only with the law. And Franklin wrote Glendora a note, and he tried to speak, but Judge Evans said it was not right. Franklin's note said that it was impossible over the years. Gelman would not come to the phone to get testimony, that we had to rely on what his office people said. 7:36 p.m. was DiGiulio's cross-exam of Glendora. He said several elements were had to be proved. He wanted to know if it were called Glendora a cheerful look at life. Yes, but he missed that there were and are several of these, not just the one that Glendora sent Gelman. We've had it sponsored on broadcast TV by Xerox and Texaco and Polaroid and General Foods and Quaker Oats. DiGiulio leaned heavily on no receipts produced, that Deuces Takem was presented. Glendora pointed out we brought 4 boxes of tapes and paper to court January 10th, and DiGiulio ignored all of them. DiGiulio made a point that Glendora made the copies, that she did not go outside anywhere to make them. This is wrong. Glendora had dubs made at ELA Studios on 59th Street and 12th Avenue, just a block from CBS. At 8:08 p.m. is when DiGiulio, failing to find merit in his defense, introduced other lawsuits of Glendora. When Glendora said, "Now, is this pertinent to the case at bar?" DiGiulio says it was an avocation of Glendora to start lawsuits and how she occupied herself. Glendora said she didn't like having reports on courts and lawyers and cases on her program, but they were fights for rights, and the information helped people, and that she received many telephone calls. Just this morning I had a 20-minute call from a man down in Manhattan who was being abused by the New York State Division of Housing and Community Renewal. Glendora called Franklin as a witness. He testified about 5 minutes. Judge Evans asked Glendora if there was anything else, and Glendora said, "I wish to call Michael Gelman as a witness." Franklin said that hit DiGiulio and Gelman like a bomb. It must have hit the court stenographer like a bomb, because she asked for a break, and this was at 8:22 p.m. Glendora had asked at the start if she could play the tapes of Calvin Norman. The judge said no, he wasn't here to testify. Glendora really thinks that the judge precluded the tapes and the log because she did not have court time to hear them. The raise to $380 was granted around 7:31 p.m. in the interest of getting this over with tonight. And at 7:45 p.m., Glendora said she had receipts from ELA that could be produced. Glendora asked if DiGiulio was under oath. No. Well, he should have been, because he was lying. DiGiulio tried to point out benefits. DiGiulio said there were no promises by Gelman he would return the tape, and Glendora said it was implied. Glendora said she would not send a tape to anybody unless she thought it would be returned to her. This is Caesar. He's fixing our front door. It won't latch. These are all things that happened before the 8:22 p.m. break. They are inserts that came from the notes. 7:50 p.m. is when Judge Evans told the court officer and the calendar clerk we were almost finished. Well, now see, how right was she? She was about 40 minutes away. I think we finished about 40 minutes later. Did Julio ask, did you send a cover letter? Glendora, no. Did Julio ask, did you send a self-addressed envelope? Well, these are all excuses. There's no excuse, Michael Gelman, for not returning a person's property. You can't find an excuse. You can't find an excuse for your lack of ethics and for your lack of upbringing. Everybody else had returned the tapes that Glendora sent to them. It was bad. The evidence of the audio tapes and the log were precluded. Glendora had got all of her videotaping done Wednesday so as to have Thursday to prepare for the trial. The notes for the other logs, TV fan just called from Manhattan and talked 20 minutes, and then Rick Mechanic called about Lincoln, and it needs a caliper. This is at 9:29 a.m. on March the 2nd when we're videotaping this. First we typed it, and these are all of the interruptions. Now I'm going to start the after discussion, writing down notes of what happened. And that was from the after discussion. Glendora brought up the question, why did Michael Gelman never return any of the 200 telephone calls over the 5 years? The question was never answered. Insert, Judge Evans wanted to know if things should be sent to 21 Greenwich Avenue. This was early in the evening. And Glendora said, no, it should be addressed to Box 416 because it takes the post office 2 weeks to get anything from 21 Greenwich Avenue to forward it to Post Office Box 416. Note that Gelman did not ask for a jury. A plaintiff cannot ask for a jury in a small claims trial. Now there was another phone call at 9:41 a.m. this morning. What is on the after notes before going to Glendora's examination of Gelman? I'll tell you all that, and then I'll tell you what happened in the examination of Gelman. Insert, Glendora told Judge Evans, I had to give up, right? Well, he did a wonderful job. He fixed it. I don't know what happened. The latch came loose and it wouldn't stay closed. But he did a wonderful job, as he always does. That's Caesar. Now, insert, Glendora told Judge Evans that she had not been paid $14 for mileage for subpoena duces tecum. Judge Evans protested a while, and then she said she would look it up in small claims book, which is where Glendora said she had seen it, 29 cents a mile for travel. Insert, DeGiulio accused Glendora of not producing their videotapes. Glendora went to one of the boxes and got out 3 videotape cassettes. She showed the 3/4 inch master to Judge Evans. Well, that would be in the box. It didn't show it to her on a monitor. She showed Judge Evans a 3/4 inch 10-minute dub, and she showed Judge Evans a VHS 10-minute dub. At that time, Glendora should have put the 120 audio tapes out on the table so that Judge Evans could have seen the evidence and seen the work and seen the time and seen the costs. Insert, DeGiulio asked Glendora about telling about the Gelman case on TV. Glendora said she was doing what Congress